I'm Ben Meiselas from the MeidasTouch Network. E. Jean Carroll's civil rape and defamation case against Donald Trump is set to go to trial on April 25th, 2023. So we are on the eve of trial, and predictably, what does Donald Trump do when we are on the eve of trial? Well, late Tuesday night, his lawyer Joe Tacopina filed a letter brief requesting a 4-week delay of the trial, and Joe Tacopina claimed in his letter brief that the reason for the delay was the need for a, quote, cooling off period based on, quote, the carnival-like atmosphere, end quote, in connection with Donald Trump's criminal arraignment. I think there is zero chance that Judge Lewis Kaplan, the federal judge presiding over this case, is going to grant this motion to delay. Judge Lewis Kaplan, the federal judge from the Southern District of New York, is very well aware of Donald Trump's delay tactics. He's commented about Donald Trump's delay tactics before in other orders. Very recently, the federal judge Lewis Kaplan made an order, again affirming a prior order, making sure that there would be anonymous jury selection and anonymous jurors who are ultimately selected to ultimately make the final findings in this case, citing Donald Trump's behavior of threatening the Manhattan District Attorney and threatening prosecutors and threatening judges. And Judge Lewis Kaplan is a no-nonsense judge, and I think that he was aware that Donald Trump would try to engage in delay tactics like this. Of course, Donald Trump, for his part, takes no responsibility for the carnival-like atmosphere associated with his criminal arraignment. He fully blames, in this letter brief that he filed, the Manhattan District Attorney's Office for creating the carnival-like atmosphere. I think we can very much expect E. Jean Carroll's lawyers to point out that the Manhattan District Attorney's Office actually offered Donald Trump a very low-profile arraignment. They offered for him to do it by Zoom. Donald Trump said he wanted to show up. He wanted the stunt. Then he proceeded to make all of these very dangerous posts on his social media platform, calling on his cult followers to take back the country, calling Alvin Bragg, the Manhattan District Attorney, a Soros-backed animal, attacking the judge presiding over the case and the judge's daughter. That's Judge Juan Merchan, who presides over the criminal case, and other conduct like Donald Trump posting photos of himself with a baseball bat looking like he was going to bludgeon the Manhattan District Attorney's Office. I want to show you now this very frivolous letter brief motion that was filed by Donald Trump's lawyer, Joe Tacopina. It was filed again late Tuesday evening on the electronic filing system. And this is what the letter says. It says, "Dear Judge Kaplan, on behalf of Donald Trump, we write to request a 4-week adjournment of the April 25th, 2023 trial date. As set forth more fully below, Trump's right to a fair trial depends upon a brief, quote, cooling off period between the trial of this matter and the recent deluge of prejudicial media coverage concerning his unprecedented criminal indictment and arraignment in Manhattan. As this court is aware, history was made on March 30th, 2023, when a former United States president was indicted for the first time. 5 days later, on April 4th, 2023, Trump was arraigned in a courthouse just steps from where the trial of this case will be held, amidst a carnival atmosphere with hundreds of demonstrators and reporters. Holding the trial of this case a mere 3 weeks after these historic events will guarantee that many, if not most, prospective jurors will have the criminal allegations top of mind when judging Trump's defense against Ms. Carroll's allegations. That is a predictable consequence of the wall-to-wall media coverage of the criminal case. The unsealing of the indictment and Trump's arraignment on April 4th, 2023 were accompanied by coverage on all television networks and resulted in at least 60,000 a day of news stories. as will be set forth more fully in Trump's forthcoming motion for a juror questionnaire. The coverage was remarkable for its volume and incitement of animus towards Trump among the veneer. So he's blaming the Manhattan District Attorney for inciting animus against Trump for prospective jurors here. Look, Judge Lewis Kaplan is not going to take kindly to such a frivolous allegation like that when it was Donald Trump who was the one posting these despicable images of him brandishing a baseball bat looking like he would be bludgeoning Alvin Bragg in these photos. Goes on to say, widely covered criminal charges against a civil litigant should raise urgent concerns over potential contamination of prospective jurors. That is true of a criminal charge of any kind, but the threat of Trump's rights is particularly dire because the coverage of the indictment has repeated a salacious and false allegation, exactly what Miss Carroll alleges in this case. Jurors selected to hear Miss Carroll's allegation against Trump will have the breathless coverage of Trump's alleged extramarital affair with Stormy Daniels still ringing in their ears if trial goes forward as scheduled. To avoid this egregious violation of Trump's constitutional rights, the trial should be adjourned for a brief period to allow the media frenzy to recede. And note there what Tacopina is saying. Tacopina is saying that Donald Trump never had any extramarital affair or never had sex with Stormy Daniels, that those allegations are false. And those are false allegations, he's saying, the same way that the allegations brought by E. Jean Carroll are false, and that the juror, that the prospective jury pool would be contaminated by Stormy Daniels' false allegations, thinking that those were true as it relates to E. Jean Carroll. Now just think about that argument and think about how that ultimately is going to backfire as well. Not only is this going to be rejected by the judge, I predict, but E. Jean Carroll's lawyers are going to maybe even cite this letter in their cross-examination of Donald Trump, and I think they're certainly going to cite Donald Trump denying that he had an affair or had sex with Stormy Daniels. I already saw in the deposition transcript of Donald Trump, in the deposition taken by E. Jean Carroll lawyers, they were asking him about all the other things that he thought were hoaxes. And he would go, Russia, 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 Ukraine, 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 that climate change is a hoax. Anything that he just didn't like, he said was a hoax, even when it was true. And now Donald Trump saying he never had sex with Stormy Daniels when he absolutely did is more evidence that he just simply lies about everything, the same way he is lying here about E. Jean Carroll. But that's what Trump's lawyer here is claiming is prejudicial. The letter goes on to say, to be sure, Trump is persistently a subject of media coverage. But the present situation is unique because, as stated above, the recent coverage pertains to alleged sexual misconduct, the same issue at the heart of this litigation. It is also unique because the volume of coverage surged upon Trump's recent indictment and arraignment. Over the last month, media coverage related to Trump spiked over 200%, with at least 211,000 articles referencing Trump's criminal indictment. It then goes on to basically say there has been more media coverage here than before. Then they try to cite this law. They go, to arbitrarily deny a continuance and thus substantially impair the defense would be an abuse of discretion. In other words, they're kind of threatening the judge. If you don't grant this delay, the Court of Appeals is going to overrule you, which is just completely false. The letter goes on to say, in exercising its discretion in deciding on an adjournment request, a district court must determine whether a continuance is, quote, consistent with the ends of justice. Here, an adjournment is not merely consistent with justice, it is required by justice and Trump's right to an impartial jury. That's just completely and utterly false. The law they cite is accurate, but its application to these facts is absolutely not. It goes on to say, the Constitution guarantees both criminal and civil litigants a right to an impartial jury. Courts have long acknowledged that pretrial publicity can taint a jury pool by exposing it to inadmissible allegations and evidence. And then it goes on to cite law that says that. And I want you to think about this for a second. You have Joe Tacopina. Joe Tacopina was on the news and has been on the news like every single weekend and almost every day. We've covered his appearances here on the MeidasTouch network. And so now he is blaming his own press appearances as creating extrajudicial pretrial publicity that is now going to potentially taint the jury pool. Like, does Joe Tacopina not realize that E. Jean Carroll's lawyers are going to be citing and showing all of the times that he appeared and gave these interviews, and he was one of the main people who fueled, you want to call it a carnival-like atmosphere? That's why him writing this is almost certainly going to backfire. And then they go on to say, there's no case where these concerns are more pressing than this one, where the veneer has been blanketed with coverage of the criminal case against Trump. You're the one blanketing the jury pool. You're the one on TV. You're the one on Meet the Press. You're the one on ABC. You're the one on all of these channels giving these absurd interviews. The one where you took Ari Melber's paper away from him. It goes on to say, the relief Trump seeks, a brief adjournment to allow a cooling off period, is modest relative to the significant prejudice created by the pretrial publicity. The Supreme Court of the United States has instructed that the passage of time can mitigate prejudice from pretrial publicity. This court and other district courts have also acknowledged this common sense principle. Then it goes on to say in the last page, the next deadline in the criminal case that is likely to generate significant coverage will not occur until August 8, 2023. Late May, therefore, marks the beginning of a 2-month window during which this case can be heard by a jury far more likely to be impartial than the one recently inundated with prejudicial media coverage of the criminal case against Trump. Now, listen to this last paragraph and read this. Trump can only receive a fair trial in a calmer media environment than the one created by the New York County District Attorney. A short postponement of the trial will allow the recent surge in media coverage to subside and increase the likelihood that Trump receives a fair trial. We therefore respectfully request the court adjourn trial set for April 25, 2023 to a date not earlier than May 23, 2023. Signed, Joe Tacopina, and also Alina Habba is a signatory as well. And just read that last sentence one more time, last paragraph rather. Trump can only receive a fair trial in a calmer media environment than the one created by the New York County District Attorney. The one created by the New York County District Attorney. Like, you realize you're the one posting all of these dangerous posts on your social media platform. You're the one creating the circus-like environment. That's why I do not think the judge is going to grant this continuance. I expect there to be even a scathing order in response to this request that's being made right here. And I'll just say this too, the judge is on to Donald Trump. I mean, in the recent order where the judge affirmed a prior ruling requiring anonymous jurors, the court said, the likelihood of difficulty since the court made these previous findings about the need for anonymous juries has only increased. That is so in view of Trump's public statements characterized by the media as attacks against the New York State judge presiding over the recently filed New York State criminal case against Trump, and threats reportedly then made, presumably by Mr. Trump's supporters, against that judge and members of his family. Nevertheless, despite never having objected to the use of a fully anonymous jury, and despite ample opportunity to do so, both parties seek to raise the subject of an anonymous jury now for the first time, and the court ultimately denies that relief, citing Donald Trump's dangers and citing the court's previous order that basically says as this properly may be viewed in the context of Trump's many statements regarding individual judges, the judiciary in general, and other public officials, as well as what reports have characterized as violent rhetoric by Donald Trump. And so I think we'll see the court deny this continuance request. We should look for that order. You never know what's going to happen, but I think that's what the data suggests. But again, a frivolous motion. And I'll make this final point. Like, do you truly believe that Donald Trump, after 4 weeks, is going to say, okay, I'm ready for trial now? No. He's going to try to come up with some other excuse now. Delay. Judge Lewis Kaplan has previously issued orders saying that Donald Trump at every stage of this process just tries to delay and come up with excuses. And so I think we'll see an order denying this request by Trump as well. I'm Ben Meiselas from the MeidasTouch Network. Thank you for watching. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. So please hit subscribe wherever you get your audio podcast as well. Just subscribe there too to the MeidasTouch podcast. It's free. And you can also check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. We got a lot of great content there for our members. And so just check it out, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas. Hit subscribe. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.